Okay, we have a new filing in James Springer's case against the 7th Judicial Court, Mercedes Murphy, Shannon Murdoch Puff, Jason Jones and Susan Rosignol. And it's a reply in support of the motion for temporary restraining order and preliminary injunction. In what can only be described as a concerning lack of candour for a defendant from the state judicial branch, the defendants here elect to engage in mischaracterisation and utter arrogance which appears to be based in the erroneous belief that they are a superior branch of government rather than a co-equal branch of our tripartite system. Specifically, defendants argue on one hand to say that the reason that plaintiff has been barred from public courthouses and intentionally excluded from public hearings is because he is engaged in First Amendment protected activities of speech and petitioning to argue with court staff. But then on the other hand, the defendants claim that plaintiff was excluded because his exercise of speech as a member of the press caused by some unnamed and unknown person not under the control of plaintiff to harass and threaten court staff. But there is no explanation of how they were harassed and threatened or why that is plaintiff's responsibility, such that it warrants stripping him of his constitutional rights with no pre or post deprivation due process. Nor is there any explanation for how such actions survive strict scrutiny by being narrowly tailored to meet a compelling government interest that would satisfy substantive due process concerns. Moreover, no explanation is offered as to why the defendant felt it was appropriate to threaten and to seek criminal prosecution in retaliation for plaintiff's protected speech and petitioning, though they admit to doing just that in their response, offering mildly obstreperous conversations of plaintiff with court staff as evidence of some sort of disruption. In essence, defendants ask this court to ignore the clear protections afforded to plaintiff by the federal and state constitutions because his reporting exposed them to public criticisms and they are above criticisms, not to mention the Constitution and the laws because they are judiciary. Argument. It is hard to fathom, much less respond to such unmoored and unsupported unconstitutional actions by the members and parts of the state judiciary. From a factual standpoint, defendants argue that their limitations are content neutral and then cite conversations that are argumentative of the court's policies. Such dichotomy in their argument should strike this court as extremely unpersuasive. They also argue that the requirements for injunction are not met by relying on the overall case of and citation. Next, defendants argue without authority that plaintiff is not a member of the press and that their wholly incorrect mischaracterization of spoliation that did not occur excuses their egregiously unconstitutional actions. Finally, defendants argue that because plaintiff argued in defiance of their unconstitutional administrative orders and attended the courthouse to further argue in defiance of the same, that they are justified in stripping away rights to speech, petitioning and press, which is directly contrary to the Supreme Court's holding in Shuttleworth v. City of Birmingham. Citation. Finding that where a licensing scheme is facially invalid for lack of procedural safeguards or unbridled discretion, a person faced with such an unconstitutional licensing law may ignore it and engage with impunity in the exercise of the right of free expression which the law purports to require a license. And that's the 1969 case. 1. As explained in the motion, plaintiff meets the requirements for a preliminary injunction. A. Plaintiff has clearly articulated loss of First Amendment and due process liberty as irreparable injury. I'll do that again. A. Plaintiff has clearly articulated loss of First Amendment and due process liberty as irreparable injury. Plaintiff has clearly demonstrated that he is seeking to remove the prohibitions and limitations that are abridging his freedom of speech, of the press, and to petition his government for redress of grievances by excluding him from public spaces and public hearings, including those held virtually, which plaintiff has properly alleged has occurred and continues to occur, clearly representing the irreparable injury of the abridgment of those freedoms, contrary to the plain language of the constitutions. B. Defendants' argument regarding prejudice to them is farcical. Defendants amazingly argue with a straight face that the two conversations that they have transcribed and included for the court in their response, which at best constitute minor disruptions, are reflective of a citizen mildly arguing with court staff to petition for redress of grievances as highly prejudicial because court operations were inexplicably impeded. But such a statement does not even begin past the smell test. There's a 2 missing there. Courts regularly enforce rules and orders by means of contempt. Here, plaintiff did not engage in anything resembling contempt of court, in the presence of a judge or in a courtroom, nor outside of minor argument with a hearing officer regarding masking policy, can be legitimately argued that plaintiff disrupted court proceedings. In fact, if the defendants were honest with this court, they should disclose that the reason they retaliated against plaintiff, as explained in Defendant Jones's letters, is because court staff are being harassed on your behalf and has impacted court resources. And there's an exhibit. What this translates to is your reporting earned us the ire of your subscribers who exercise their own rights to speech and petition to complain, and we don't like it, so we are excluding you from further reporting in the future. The judiciary is not immune from criticism by the public, and they cannot claim prejudice as a means to exclude unfavourable press. C. Stopping part of the state's judiciary from violating the constitutional rights of a citizen through unappealable administrative orders is not averse to the public's interest. As explained in the motion, the 10th Circuit recognises that it is always in the public interest to prevent the violation of a party's constitutional rights, and there's citations. It is in the public interest to not allow government to ban members of the press from public courthouses and hearings, or to deny them the ability to make records requests simply because they do not like the content of the speech or press of an individual reporter. Quite frankly, despite the arrogant protestation of the defendants, the fact that they represent part of the state judiciary does not alter that analysis. D. Defendants utterly fail to rebut the likelihood that plaintiff will prevail on the merits. This cornerstone of First Amendment protections has been reaffirmed time and again by the Supreme Court, this court, Texas Court of Appeals, legal treaties. Hang on. Why are we saying Texas Court? Oh, is that a quote? Okay. It's a quote, sorry. So this cornerstone of First Amendment protections has been reaffirmed time and again by the Supreme Court, this court, Texas Courts of Appeals, legal treatises, and even, I imagine that's treatises, and even popular culture. And there's citation. For your information, the Supreme Court has roundly rejected prior restraint. Instead of addressing how they have not violated plaintiffs' right to speech, press and petitioning, not to mention substantive and procedural due process, by engaging in clear prior restraint to explain why plaintiff is unlikely to succeed on the merits, defendants engage in an argument of non sequiturs about how plaintiff has not shown the level of deference they believe they are entitled to for following court rules as well as unconstitutional administrative orders. The presumption this court shall find is that plaintiff is likely to succeed on the merits because any system of prior restraints of expression come to this court bearing a heavy presumption against its constitutional validity. The citation. Judge Browning has provided a clear analysis of the law regarding prior restraints, stating, in the abstract, prior restraints are contrasted against restrictions that provide for subsequent punishment. Dean Erwin Cherminsky provides the following guidance in his Hornbook. It is too broad to say that a prior restraint is a government action that prevents speech from occurring. All laws outlawing speech would constitute prior restraint by this definition. Nor is the traditional distinction between censorship before speech and after the fact punishment sufficient. All punishment for speech, whether under prior restraints or other laws, occurs after the expression takes place. All government actions regulating speech, whether prior restraints or not, exist before the speech occurs. The clearest definition of prior restraint is an administrative system or a judicial order that prevents speech from occurring. And there's a citation. The best way to determine whether a given speech restriction is a prior restraint is to consider the reasons for the heightened scepticism towards prior restraints in the first place and determine whether the speech restriction in question implicates those reasons. It is not immediately obvious why prior restraints are disfavoured. Prior restraints thus have the effect of absolutely suppressing speech with no opportunity for after the fact vindication by the speaker, at least until they are challenged and overturned. If the prior restraint is never challenged, for example, if the restrained individual lacks the resources to fight the government in court, then it acts to permanently prevent the restricted speech from entering the marketplace of ideas. Courts have been most likely to find that a speech restriction is a prior restraint when the collateral bar rule would apply to a violation of the restriction. In practice, most prior restraints involve either an administrative ruling requiring some form of license or permit before one may engage in expression, or a judicial officer directing an individual not to engage in expression on pain of contempt. Citations. It is clear that defendants make no effort in hiding from the fact that they have engaged in prior restraint and First Amendment retaliation, because plaintiff has the audacity to argue with them, and his reporting of their misfeasance and malfeasance expose them to the public's ire. Moreover, they again argue without authority that plaintiff is unlikely to succeed on his claims for abridgment of his rights to press, as well as, more importantly, to procedural and substantive due process because they disliked his behaviour or for minor violations of court rules on a singular basis. Tellingly, defendants dishonestly offered to this court that the criminal contempt proceeding that was initiated in retaliation as a vindictive prosecution remains pending in the 13th Judicial Court. It does not, because the special prosecutor has determined that there is not enough information to support going forward with a charge of contempt. And we'll see the exhibit. That's the first I've heard about that, so we'll see the exhibit attached here too. Thus, defendants cannot actually sustain that their actions to deny First Amendment freedoms and owing due process are justified by actual contemptuous actions by Mr. Springer, and therefore plaintiff is likely to succeed on the merits of his constitutional claims. This clearly unconstitutional conduct by defendants is likely why they have waived any legitimate argument supported by law that the plaintiff is not likely to succeed on the merits in their response. 2. Defendants' ad hominem characterizations of plaintiff and discussions of reasonableness, lack of rights of the press to special treatment, and the role of judicial forum are irrelevant to the motion. Quite obviously, reasonable restrictions can still be unconstitutional. Plaintiff only once carried a camera or recording device into a courtroom when he was ignorant of the rules. The next time he tried as a member of the press to observe and record an open court proceeding as a member of the press by appropriately giving notice to the presiding judge. That judge, defendant Murdoch Puff, issued an order prohibiting him from attending the hearing in any capacity. The disruptive conduct the defendants now assert, different than their previously stated reasons, are two conversations provided to the court which can at best be described as cheeky, with no explanation or evidence for how they disrupted court proceedings, other than by causing an annoyance of court staff that somebody was not as polite with them as they might like. Likewise, defendants engage in mischaracterising plaintiff as not a member of the press. Luckily, we do not let the government decide who is press and who is not, because that would of course abridge that right. But just to place the question beyond dispute, plaintiff respectfully offers that he has over 440,000 subscribers to his YouTube channel, which is approximately the same number of subscribers as the YouTube channels of F.UK.T, KRQE and KOB combined. More importantly, plaintiff is not requesting special accommodations as a member of the press. He is just asking for equal, unabridged access to the public areas of the courthouse to be allowed to attend and video with appropriate notice public hearing. Finally, defendants dishonestly offered with no evidence that plaintiff has engaged in spoliation. To begin with, the defendants mischaracterised the plain statement that plaintiff made that as a prior practice that he deletes information that he receives from confidential informants. That has been his long-standing practice as a member of the press to protect his sources from government intrusion. It does not constitute spoliation because information received by a member of the press from a confidential source is not discoverable by the government. There's citation. Moreover, plaintiff is clearly reiterating that he has been advised by counsel that he needs to preserve information going forward, even if it is protected by First Amendment privilege, even though he had not previously done so. This is a red herring that, even if true, is unsupported by any authority that determines that in a civil rights context that the government is excused from violations of rights or that injunction is improper if confidential source information was deleted prior to a preservation letter. The sheer audacity of the defendants to claim that it needs plaintiff's private information to justify their abridgment of his constitutionally protected rights after the abridgment has occurred is startling and beyond disappointing. To have such a claim advanced by the government, much less part of the judicial branch in America. Conclusion. It is worth noting defendants' response is not a pleading that comports with the requirements of Rule 12, meaning that they remain in default. Moreover, despite grace of this court to sua sponte allow for additional unrequested time to respond to the motion for TRO and PI following the complaint, defendants have failed to, in any reasonable or legitimate fashion, to explain to this court, supported by authority, why the injunction requested by plaintiff should not issue. For these reasons, the plaintiff respectfully requests that the court hold the defendants to the same laws that the other branches of government must follow and enter a preliminary injunction for the pendency of this action without further delay. And that's being respectfully submitted. Right, let's have a look at the exhibit. So this is a notice of non-prosecution. Okay, it's dated the 1st day of September. And it's from the 7th Judicial District. So it's notice of non-prosecution. Comes now Marco P. Cerna, Special Prosecutor for the State of New Mexico, and informs this court that the state has not received adequate information to move forward with the prosecution regarding the matter involving Mr. Springer. Respectfully submitted. So that's quite an interesting one. I'm assuming that although it doesn't mention the 13th district, which is where this case has gone, that they're not prosecuted in the 13th district, but that one will need a bit more research. But possibly he isn't facing prosecution for his contempt. Thanks for watching.